Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. Taking note of the continuous supply of cases seeking bail after filing of the final report on a wrong interpretation of section 170 of the Code of Criminal Procedure bracket hereinafter referred to as the code for short bracket close, an endeavor was made by this code to categorize the types of offences to be used as guidelines for the future. Assistance was sought from Shri Siddharth Luthra, learned senior counsel, and learned additional solicitor general Shri S.V. N.B.W. on failure to appear despite issuance of bailable warrant. NBW may be cancelled or converted into a bailable warrant oblique summons without insisting physical appearance of accused if such an application is moved on behalf of the accused from oblique before execution of the NBW on an undertaking of the accused to appear physically on the next date of hearing. Bail applications of such accused on appearance may be decided widow of the accused being taken in physical custody or by granting interim bail till the bail application is decided. The trial courts and the high courts will keep in mind the aforesaid guidelines while considering bail applications. The caveat which has been put by learned ASG is that where the accused have not cooperated in the investigation nor appeared before the investigating officers nor answered summons when the court feels that judicial custody of the accused is necessary for the completion of the trial where further investigation, including a possible recovery, is needed, the aforesaid approach cannot give them benefit, something we agree with. We may also notice an aspect submitted by Mr. Luthra that while issuing notice to consider bail, the trial court is not precluded from granting interim bail, taking into consideration the conduct of the accused during the investigation, which has not warranted arrest. On this aspect also, we would give our imprimatur and naturally the bail application to be ultimately considered would be guided by the statutory provisions. Thus, it is not as if economic offences are completely taken out of the aforesaid guidelines but do form a different nature of offences, and thus the seriousness of the charge has to be taken into account, but simultaneously the severity of the punishment imposed by the statute would also be a factor. Jails in India are flooded with under trial prisoners. The statistics placed before us would indicate that more than two-thirds of the inmates of the prisons constitute under trial prisoners. Of this category of prisoners, majority may not even be required to be arrested despite registration of a cognizable offense being charged with offenses punishable for 7 years or less. They are not only poor and illiterate but also would include women. Thus, there is a culture of offense being inherited by many of them. As observed by this court, it certainly exhibits the mindset, a vestige of colonial India on the part of the investigating agency, notwithstanding the fact arrest is a draconian measure resulting in curtailment of liberty and thus to be used sparingly. In a democracy, there can never be an impression that it is a police state, as both are conceptually opposite to each other.